of those anchors that are on CNBC make a lot of fun. I'm almost an hour.
A lot of them are, you know, Harvard grad, IB grad, former, you know.
So they have to be good at speaking and, you know, they can talk about it.
Even like some of the young girls.
Yeah,
They're hosts.
When Florida is doing the interviewing, like really, like Warren Buffett was on there, I think on Friday.
Buffett Hardin.
Like everybody.
Yeah.
There was
No
suggestions and
no
no opinions. They just try to ask him what do you think. They ask him everything.
It's pretty much invaluable.
Are you going to be using the computer at all, or?
No, okay.
I'm just going to turn it off completely.
Oh, okay, cool, thank you, that'd be great. Yeah, I'm gonna do my best. I'm gonna have to look at my notes, so I will be pretty much right here for your focus.
Okay.
As opposed to out in the middle.
And I think,
Is it pretty wide angle?
I think both of these are all legal.
He just kept driving around.
Is that what this is?
Coming back. It was like the funniest thing.
Yeah.
It's the same thing, so you use them on, I mean, they look like many markers.
Yeah, that's
They're made for this and
Yep,
they're racial.
precisely.
I go to Target.
Okay.
All right, well, thank you, buddy.
You all fancy?
Target.
Good, folks, enjoy. We'll see you guys next week.
We will do our
tell you
very
about it.
best.
Blaming me already?
Yeah, homie.
Alright.
Oh, you did that one.
Why not this one? I looked at what it was about. And it said, we should be close to this.
Well,
Good morning.
Good morning.
certainly not gonna start for a minute, we may have some stragglers coming in. Is Kathleen here?
Right here.
Hey, do you have a book?
Yes.
You got
thank
one?
you. I got
Okay,
it.
great.
I wasn't
One.
able to get one.
I've got one more. I kind of promised it to Juan. Is he? I don't see.
He's here. He's on the map.
Okay, yeah, I made it. Sorry to hear you guys had problems. I hear the bookstore, even as of yesterday, still had some.
Well, I'll go down there. I ordered it on Amazon from like another vendor, and they said it would be here on the 2nd, and I looked, and they said maybe the 20th. So it's not going to work.
Yeah, that's the
Kathleen,
scary
could you
thing.
tell, did they have a few?
I went to the bookstore on Thursday and I got the last copy. They
Oh, that was the last?
Oh, that was the last one they
Oh,
told me
okay,
they had.
all righty. Sorry to might have been easier to get the new 8th edition, but it costs a couple $100, and I didn't think anybody would be too hot for that.
Yeah.
Just to tell you this,
Mike is fancy.
they revise this book about every 4 years, and they change like nothing except the cover. And that's why the 6th, I have an old 6th here that I promised to Juan until he gets his, and if you guys can share off on this somehow. I think it's identical. I think it's going to be the same stuff. And I'm guessing the 8th is going to be the same stuff, and the publisher has sent me one, and I'm going to resist switching to that if there's nothing different. And we'll just, you know, not that that affects you, except maybe gives you the ability to sell your book, if we can stay with the 7th. In any event, I had no idea that Amazon couldn't send it to you in a day or two.
Yeah. Well, it's not Amazon. It's like one of their
Oh, the vendor sends it direct, and then they don't control when it comes.
She's not taking it.
But they had quite a few, didn't
What?
they?
No, well, I ordered the first one, and they sent me an email back like 3 days later canceling the order because they didn't have any. And it's like, I found another supplier on Amazon, and they said guaranteed delivery on October 2nd.
Well,
I checked it yesterday, and it said October 2nd to October 20th.
when I checked, they had 13, 15, and then there were some other vendors, and
So I just
I thought there were
probably
going to
grabbed
be
the wrong
plenty.
one.
Do you know what may have happened? I heard, at first the bookstore said we're not going to have any. And then I got another email that said we got 7, but we obtained them elsewhere. They may have taken 7 of Amazon's, and in which case the grand total was
That's
still.
probably what happened, because on Thursday I went online and it was $79.99. On Saturday I went to actually buy the book and it was $132.
Well, what'd you get? Is that new?
No, it's used.
I paid 100 and something for mine and used it.
I saw some on there for,
I'm gonna
yeah,
get you
15,
some.
20 bucks. That's what I thought everybody would be doing.
15, 20 bucks.
What?
What did you?
15 or 20, yeah.
I wish.
Mine used at the store.
Pay
was
178.
So criminal.
How much?
We got ours from the same place.
What was
I'm gonna
that?
hurt you though.
73 all the way,
No
man.
one's looking. You just watch.
I think mine was 71
That's why I
though.
stayed with the old
100%.
edition, was trying to hold the price down. And to resist that new 8th edition, they were trying to cram down on it.
But I think he got it for the same price. Mike got the 8 for
said
the
something about
same
130.
price as I got
Did you?
the.
Yeah, I
But somebody got the 8?
I got the 8.
What'd you pay for it?
I paid like 130 for
Well,
it.
it's pretty.
I love the reaction. It's pretty.
New?
And was it, did you get the 8 because that's all you could find?
That's all I could find.
Wow.
Is
Did
it
you get
new?
it? Did you
It's
get
new,
it?
right?
Huh?
New or used?
No.
I might as well just buy that
Because
one.
you did it on Tuesday.
Mine's just fancy.
How long did it take to get to you?
48 hours.
On Amazon?
Yeah.
I'll just do
He
that.
probably chose fancy shipping.
Just rent it.
It's gonna make a great cocktail book one day, so you know,
Anywhere.
just have it on there.
Oh, Vader books.
Let me count heads and see if
Okay.
What the
we're.
heck?
I rented mine from Barnes and Noble.
Like you went to the store?
Yeah, we're waiting for a couple more. Could I take a look for a second?
Absolutely.
They have a new one waiting for me because they want to pitch,
Mhm.
but I haven't seen it yet. I just want to compare table of contents and see what they've done.
And what, they just ship it to
The
you?
first
I can't remember.
4 chapters
You
are,
have to
if
return it
it
and
was
they-
the overview
they
that you
pay
stated
for
so,
the
but it really is, I mean, it goes from,
Print it out.
it goes into like real property, personal property, the appellate courts, all those type of
Okay.
structures, so.
Well, it's pretty much the same.
Oh, good, yeah.
So that's, I asked them, other people, if that's what they read.
I don't know.
Um,
Well, you know, some people are not here today, so he said he was recording for them.
Oh, cool.
Hope you don't hear me saying this.
I'm pretty sure it can. Shh.
Be quiet, Nicola. Stop talking.
Yeah, first 5 are the same.
Okay.
Good. But just in case, we may have people using 3 different editions. When we talk about the assignment for next week, let's talk about the names of the chapters, just to be sure that
Okay.
we're all talking apples and apples.
That book doesn't look like Michael opened it yet.
Yeah.
Check the highlighters.
Check my highlights.
I think up through 13, for sure, they're still named the same, which is
Oh my God.
today and next week. And by then I'll have one, and I'll make sure that, anybody else have 8?
No, Mike's just fancy.
Okay. Thanks.
High roller over there. High roller. Big ball.
I think we're looking for 14, 4, 10, 12. Let's give it another minute.
Well, there's another one that's missing because his daughter's.
Yeah, should be 16. I've been told 16, but the 2 wouldn't come, and we have 14. So we may have 1 or 2 trying to find their way, particularly if few people are. Yeah, few are brand new. I mean, some people are starting the program right now, as I understand it, so they may have the problem of which building is it and all that kind of crud. And several, what did y'all, is this the room everybody's used to coming to, period? I mean,
Yes, sir.
Yeah.
because I had several people ask me which room, and I went, you know.
423,
I
right?
knew 4th floor. 1, right?
Yes.
Okay. 1, this is a 6th.
Okay.
I mean, a really old 6. This belonged to a prior professor.
Okay.
So please don't write in if you would. I have to give it back to me, but you're welcome to read it. The
Don't worry.
chapters match.
Perfect.
And then I'll just trade with you next week.
Perfect.
Looks like it's got some notes.
Check those and pick them up. Be sick or something.
What about,
Frederick? Fred's on his way, he's running a little late.
okay, so Frederick is coming.
All right, well, let's kind of get started maybe with some preliminary stuff. I'm Steve Ginestra. I know spelling that is weird. It's Ginestra, real easy. I'm your instructor, of course, and I'm looking forward to doing the course with you. I want to say a couple introductory things and then some kind of procedural things, and then we'll get right into the material. There are 2 important overall things that I want to try to stress, and these are just the lessons that I'm looking for that I'm hopeful that y'all will take out of here. And the first is to know when you need to contact a lawyer. I'm not trying to sell legal services, I'm not trying to sell other lawyers' legal services, but I want you to know when you get in over your head, you're gonna have some familiarity with these concepts, of course, as a result of what we're talking about. But I'm hopeful that you'll pick up on, okay, I'm in too deep here, and I need to get some professional help. And that's not necessarily a lawyer, some sort of a specialist, a surveyor, an engineer, an architect, whatever. Hopefully you'll walk out of here with a basic understanding of the concepts we're talking about and the level to which you can handle them, and then the level when it's over your head, maybe you ought to seek help. Secondly, I'm trying to convey the vocabulary. Lawyers, as you know, talk in Greek language with all these weird words. They're not that difficult. But I want you to pick up the vocabulary so you can talk to lawyers when you have to. But that's going to apply to talking to a lot of people. Bankers, brokers, surveyors, engineers, appraisers. A lot of these people use the terms that we're going to use in here. You may or may not be familiar with them. And that, of course, turns on what your work experience is, whether you dealt with them before. But a lot of these words I think are going to be new to you. And I really believe that you'll hear them from time to time, and I want you to be comfortable with them. So that's kind of the overall of where I hope we're going. I would like to discuss a few procedural things. First of all, I'm required to take roll. So I'm going to pass around a roll sheet. To the right of your name, there's a day 1, day 2 column. Just sign your name in there somewhere if you would, and get that back to me. As I understand it, this procedure is new to me too. I'm going to get an email on Monday and say who was here. And from this, I'm going to be able to respond who attended. Now, as we go through stuff, if you have a question, please stop. Please raise your hand if I don't see you, or wave your arm, or interrupt me if I'm not seeing you at all. I want you to ask questions anytime something isn't making sense. I'd like you to do it loud, please, for the benefit of everybody in the class, so that everybody hears what your question is. And if it sounds to me, I'll kind of be the judge. If it sounds to me like it's helpful to everybody, we'll do it. And if it's not, I'll ask you to come see me later, during a break, after class, whatever, and we'll talk about whatever your question is. But please don't hesitate to stop, because I don't want to move on beyond something and you didn't get it, and you miss your opportunity. Secondly, I want to talk about lunch break. Real important. I think, as you all know from the schedule, we're supposed to go from 10 to 12 and break for an hour, and then go from 1 to 5 in the afternoon. Well, that's going to be tough. It's tough to stay awake for all of us, and that's a long stretch. I'd like to, with everybody's permission, shoot for more like 1 o'clock on lunch. Is that good? What I'm trying to do is to maybe do 2 3-hour sessions rather than an awful 4-hour afternoon where we're all nodding off. So if that's good, we'll target 1 o'clock. Hopefully we'll come to a decent break in there somewhere. If anybody can't make it, get starved sooner, obviously. I'm sure most of you all know better than I. There's a break room on the 4th floor with sodas and some limited food. Secondly, as far as the lunch break, I'd like to pitch that we take a half hour. The reason is we can leave at 4:30. And I'd like to quit at 4:30 on Saturday and go do something else, and I bet you all would too, if that works for everybody. If you bring in something to eat, surely you can eat in a half hour. If you got to go to Subway or somewhere, feel free to get a sandwich and bring it back here. But does that suit everybody to do a half hour and then target 4:30? Anybody know?
That's good.
That's the plan. All right, we'll shoot for 12:30, 1 o'clock to stop, and we'll stop for a half hour and then we'll go. Grades-wise, here's what we're going to be doing. Thank you very much.
I haven't.
You didn't? Okay, and somebody hang on to it in case one more person comes in. I think we're, am I right with you, or are we going to have 13?
You know, Frederick is on his way.
Yeah, I should have 2 vacant. And I got 3 vacant, so I'm looking for Frederick Jackson.
Yeah, Maricela is not here.
Yeah.
Yeah,
Marcelo wasn't gonna come, right, as I understood. Are you coming?
You said he had a baby?
Okay.
Said he was running late.
And Alyssa, okay. If anybody knows Frederick Jackson, he's still got to sign if he comes. Grades. No paper. The syllabus talks about you're going to write a paper. Well, you're not. I don't think that's constructive. I think it's way too limited and focuses you on too small an area. We're just not going to have a paper. But we're going to have tests. We're going to have a midterm during our third session. And we're going to have the final exam on the last day. But the whole last day, the whole last 6-hour day is not going to be all exam. We're going to have a lot of material to cover, and I think we're going to be lucky to get through it all. So a goodly portion of our 5th class will be material. And then at some point in there, we'll do an exam. We'll see how it goes, but I'm guessing it'll be an hour and a half or 2 hours long, and we'll do 4 hours of other stuff. Midterm will be significantly shorter, and it'll be sometime during our third session. And we'll just see where that works into how we're doing, but more likely it'll be in the morning on the third session so that you'll be chipper and awake. And occasionally a quiz. Maybe a pop quiz on what we talked about today, see who's paying attention. And maybe one on the reading assignments to see whether you read it. So it may never happen, but it might happen frequently depending on the sense that I'm getting of whether people are prepared or whether they're not, and whether they're paying attention or whether they're not. So we'll just see how that goes. Your grade then will be comprised of your test results, of course, the final, the midterm, and any quizzes, and hugely based upon your class participation. I'm hopeful I can quickly learn everybody's name, and I'm going to ask you all to help me with that. But I want your comments, and when we're talking about something you know something about, share it with me, please. The only way I'm going to learn anything is from you guys telling me, and I'm here to learn some stuff. But you can learn a lot from each other too, and a lot of these topics that we're going to hit on, you all have been there, and you've got some good experiences to share, and I'm going to count on you to do it, and I'm going to require you to do it. So it's an important component of your grade, is your input in the class too. I'd like you to speak loud, and by the way, am I speaking loud enough? Can everybody hear me? Thanks. Please speak loud so that everybody can hear your question or everybody can hear your comment, and I don't want to have to hear it and repeat it and translate for everybody. So speak up anytime you've got something. In addition to the textbook, we're going to go through a lot of legal documents. There are 4 or 5 that I think of right off the top of my head. Real estate sales contract, the lease. Next week we're going to discuss the lease. Real legal documents. I'm going to send you by email prior to the class a form of some type. It might be a 20-page lease, it might be a 30-page mortgage, it might be a 1-page deed. Look at it. We're going to talk about it in the next class. Print it or not as you see fit. That's up to you. Because I'll have a copy with me, and I'll be going through it, and I'll have notes of things I want to cover, and you may want to make notes right onto the instrument of what we talk about. But these are real legal documents from real transactions that you're going to run into. As I mentioned, a contract, sales contract, lease, closing statement, mortgage, note and mortgage, deeds, and maybe some more. I'm going to send them to your NOVA email address. I know a lot of people resist that, but I've been instructed that the university wants it done that way. So check your NOVA email address. At the end of a class, hopefully I'll have had the ability to have gone forward enough in the text previously to give you the next week's reading assignment. If I don't, I'll email it to you by like Monday, the following Monday, so that you'll have 12 days or something to cover it for the next class. We're going to sort of follow the syllabus, but not really. Of course, we're gonna ignore that thing in the syllabus that says you're gonna have presentation of papers, because there's not gonna be a paper. But in addition, we're gonna alter the reading assignments, and we're already gonna alter them for the next class. This 1 through 5 for today was fine. I'm gonna learn a lot today of how fast we move and whether we get through all that stuff by 2 o'clock and then do a few other things, or whether we're struggling to get it finished, and we'll see. But I will definitely alter the assignment for next class for sure, partly based upon how far we get today. Lastly, I need to know something about each of you. We're not going to do the stand up and show and tell and all that stuff now. But I prepared a form that I'm going to ask y'all to please fill out and get back to me at lunch hour. And pass my one, thank you. I'm not trying to pry, but I've asked you where you've been to school before, what degrees you have, what your majors and minors were. I need to know this stuff because I need to try to set the level of the class to kind of the meaning of everybody's experience. Secondly, I've asked you about your work experience. What do you do that relates to real estate? Or what have you done that relates to real estate? What were your duties? What do you know already? I need to know that. That also may mean you're going to get called on that subject, but that's good. I think I asked you a couple other little things. Did you ever take business law? Anywhere. The first thing we're asked about degrees, I don't want to hear about high school. Where'd you go to college? What your business major, minor, stuff like that. Great, thank you very much.
Can I have one?
I'm sorry.
You're on the wrong side of town.
Yeah.
I think the last thing is I asked what term you're in this program. As I understand it, this is a 4-year program. Excuse me, 4-term program. So just put what you finished. 1, 2, 3, or 4. What have you completed? Not what term is this now, but what are you through? So I wouldn't expect anybody to put 4. As I understand it, that's done. But previous terms. Give me these back at lunch. Fill them out sometime today when I'm doing something particularly boring. And I'll read them over. I'll think about them during the course, and it's just going to help me try to evaluate the level of my audience. This is my first time teaching here at Nova, first time teaching this class, certainly first time in this program, so I really just don't know. I kind of know the curriculum in terms of what the courses are, but I don't know who's taken how many, and I know if you're brand new, you've had none of them. And maybe you're right out of college. And maybe you don't have any work experience in real estate. That's okay, but I need to know that. And that's kind of it for the preliminary stuff I wanted to cover. Anybody have any questions? Sure.
How
Tell me your name if you would.
My name's Dustin Anderson.
You're Dustin, okay,
Dustin,
thanks.
yes. The midterm and the final, how are you going to do there? Like multiple choice, short answers? You can do it off the textbook or class notes?
It will not be open book. Is that what you said?
Or just like mainly out of the book or out of your class notes, or just get kind of an idea?
It's going to be some of both. It definitely is going to be some stuff we've talked about in class that may have been teed up in the book. We're going to follow the book as our guide for what do we cover and when, what the subjects are. But I'm going to get way afield in Florida stuff. Your book obviously occasionally mentions Florida among the, here's 10 states that do this, and one of them is Florida. But I'm going to focus on Florida law. I'm assuming that y'all are going to work in the real estate business here in Florida. If not, I'm sorry, you're going to hear a lot about Florida and how we do it here in Florida. And a lot of that stuff, of course, won't be in the book. As to, I doubt there'll be any multiple choice. I anticipate short questions, short essay type questions, where I may say, what's this, and expect you to write 10 lines on something. I don't want 1 hour, what I call blue book answers, where you write the great American novel on some open-ended subject. It's going to be fairly specific. Did I answer your question?
Yes.
Okay. Anybody else?
Is that going to require us to memorize certain statutes?
You mean
Or
like
just understand the concept
seven
behind it?
amendments?
Yeah, like
No.
7 section such and such.
No. As far as, it'll never be Florida statute number NIN.
Okay.
I may tell you that in passing, that my hope is that that'll help you go find it if you have to look for it. But it'll never be, what's chapter 718 of the Florida statute?
Okay.
But it may occasionally be, what are the 3 most important reasons for having a promissory note along with a mortgage?
Okay.
That might be 3 things to remember, but we'll have covered them heavily, and they won't just be memorize A, B, and C. There'll be things that we talked about at some length. Anything else? Okay, well, I think we'll have at it, and if Frederick joins us later, great. And we'll try to take a break every now and then. That doesn't mean we're going to go 3 hours until 1 o'clock. So let's do a 5-minute break every now and then, and if you need to get up and go, do it. And if I do, we'll call a break. All right, chapter 1.
Before we do that, would you be able to give us a little background on yourself?
Oh, sure, I'd be glad to. I'm sorry, and I had assumed that a few of you had read the, what I'm going to tell you is pretty much what's in the biographical thing on the website and all, but I'm a Fort Lauderdale real estate lawyer. I've practiced law, and exclusively real estate law in Fort Lauderdale for 42 years. I started real young. Grew up here, went to public school here, went to Vanderbilt University, majored in business administration, minored in economics, went directly to law school at Florida State University College of Law. While I was there, I worked for the legislature, drafting legislation. Some of the first chapter we're going to talk about, I'm going to hit pretty heavily because I think it's important stuff. It's about statutes and laws and where they come from and how we get them and how to access them and all. But that gave me a good understanding, I feel, of government and of how it really works in the real world rather than just in the political science textbook. And then I came back to Fort Lauderdale. I practiced law with what in the 70s and 80s was a pretty good sized firm. Had 15, 20 lawyers. I was a partner in that firm for 17 years. We represented a savings and loan association. Some of you may be so young you've never heard of those. They've been gone for a long time. Those that survived became banks. But savings and loan associations were the biggest mortgage lender traditionally in the history of banking in the United States. And so we closed lots of residential loans. We closed lots of commercial loans. That savings and loan association, like all of them, ultimately became a bank. I lost interest in it at that point and left the law firm and opened my own practice, and I practiced law alone by choice in Fort Lauderdale for another 25 years. I have represented mostly developers. We're going to focus on commercial transactions as best we can. A lot of the forms we're going to use are residential because residential is where you get forms. Commercial transactions just don't have a fill-in-the-blank form and stuff like that. Commercial transactions are, usually drawn up by lawyers, and each lawyer has his own forms and does it the way he wants to. And if I gave you any one, it's going to be different from everybody else's. The only kind of generic things are residential forms, but they tee up the same issues. The issues are there, they're just bigger numbers, lots more zeros in the commercial deals and a little more sophisticated, but the issues are the same. My developer clients did a lot of projects in Fort Lauderdale and an awful lot in Coral Springs. I have done deals all over Florida, but primarily, of course, focused in the 3-county area here, and most particularly in Broward County. primarily what I did for those developer clients was their financing. I represented them as borrowers in all kinds of commercial loans. Acquisition loans when they bought the property, development loans to put in the infrastructure, construction loans to build a building, permanent loans when it's done, when they get leasing thresholds met and they got enough tenants in, the lenders will give them a permanent loan then. In the old days, those were 20-year loans. Now they're maybe 5, maybe 7. And then of late, unfortunately, I represent a lot of those same clients in what we call workouts. And workouts are where a deal goes bad. And lenders could take the property back if they wanted to, but lenders quickly figured out this isn't good. We don't know how to run this thing. We don't really want to take it back. We'll try to work with you, the borrower, to keep it alive. And so in those deals, you're going back and restructuring the loan documents, and you're doing something something realistic that the borrower can maybe live with and try to keep it alive. Ultimately, some of them go under anyway, and the lender takes it and sells it. But if you have a good, hard-working borrower that the lender trusts but knows that times are tough and tenants moved out and the rent isn't there, fortunately, lenders tried to keep their customer, the borrower, in place and let them manage for a while. Those deals are called workouts, and those are what we do mostly now. Unfortunately, unless you're Terry Stiles as an example, it's hard to get financing today. You got to be big, you got to be strong, and it's not like the boom days of the early 2000s. 4, 5, 6, when everybody was closing everything, and of course all those things have turned upside down. So there's not a lot of new loan closings going on, and that's because lenders won't make the loans. And I'm sure you all have seen financing is difficult even for residential borrowers. Most residential deals are cash deals today. A lot of commercial deals have to be cash deals because the lenders just aren't making the loans, and that's unfortunate. The Federal Reserve says it's trying to encourage lenders to make commercial loans to get development going, to provide jobs for construction jobs and pump up the economy, but it's not happening. When they come in and regulate the banks and they find the bank has made a commercial loan and it goes bad, boy, they just get all over them. And the banks shy away and say, okay, fine, I'm not doing those kind of deals anymore. And so it's tough. It's tough if you're a little developer. But that's kind of the stuff I've done. Any questions on that? Sir?
Do you get student discounts?
I'm sorry.
Do you get student discounts?
If you move your hand away from your mouth, I can hear you better. Tell me.
Do you get student discounts?
Student discounts.
Valid question.
That's kind of you. And let me tell you candidly, I'm slowing down. I've done this for 42 years. I finally had the time again to do something like this, which I wanted to do. I used to teach real estate law at night to bank employees and Savings and Loan Association employees, and I loved it. And then I got too busy to do it, and I had 30-some years of working too damn hard, and I'm over it. So thank you. Yes, I would give you a discount if we were going to do something, but 99 times out of 100, I'm going to say thank you. Let me find you a good lawyer who wants to work, I really kind of don't. I'm doing my best to withdraw from it. It's not easy, but that's where I am. But I still have an office. I'm still going in every day, but I'm referring out just about everything that I can. Anything else? Otherwise, we're going to hit chapter 1. As I said, you'll be able to tell from the length of time we're going to cover chapter 1 that I like this stuff. This is how the legal system is set up, the sources of our law, where it comes from, court system, stuff that I think you need to know. You need, I don't say that like memorize this for the test, stuff you need to be familiar with, because you're going to try to look up some of these things in the future, and if you don't already. There are basically 4 sources of law. That's one of the types of things. 4 things. You need to remember that. First one is constitutions. Everybody's got one. We all think of the U.S. Constitution. Florida's got a constitution. County has a charter. Cities have charters. Those are their constitutions. Constitutions set up the framework of how the government's going to work. Not just the Bill of Rights, and you have the right to bear arms and all that kind of stuff like in the amendments, but it's the framework of government and the different areas of government, the legislative body, the executive body, the judicial, and those are created at every level. Now, not everybody has a judicial branch. You don't have city courts anymore, but I mean, the concept is the Constitution is there to set up how's the government going to function, who's going to do what, and that's the first source of our law. Interestingly, the federal Constitution leaves local law, as it describes it, to the states. Doesn't mean they stay out completely, but the theory is local law should come from the states. And that's why you're going to find the majority of your law as to real estate is local, meaning state, city, county. State particularly.
And what do they call that again? Like home rule or something like that?
I'm sorry?
What do they call that again? Is
Well,
it home rule or something like that?
There's something called the federal preemption document.
Yeah.
Where the federal government requires states not to legislate in areas that the federal government has already legislated, and not to legislate inconsistency. Home rule is a kind of a generic word for all local governments. You're exactly right. It's at all the different levels. For the feds, home rule means states. For the states, home rule means counties, local school boards, all those concepts. That's all home rule is. As close to the people as you can, rather than way up here, down here. That's a good term for it. Thank you for sharing that. But I want you to realize, therefore, most real estate law is not federal law, with a few exceptions. And there's always going to be exceptions to everything we talk about. Bankruptcy. That awful concept of bankruptcy court. People file in bankruptcy. Well, all federal law, all bankruptcy law is federal law. You hear about Chapter 7, Chapter 11, Chapter 13. Those are all from the United States Code. Bankruptcy practice all takes place in the federal courthouse because it's a federal law. Very, very local issues involved. You know, mom and pop's pizzeria is going Chapter 7 and liquidating, but it's going to take place in the big federal courthouse downtown. Truth in lending, regulating banks and loans. RESPA, the Real Estate Settlement Procedures Act. We'll talk about it some length later, but that dictates how closings happen, how closing statements are done. The EPA, lots of environmental law comes out of the feds. That doesn't mean that the states don't also have environmental departments, but this stuff starts at the federal level. Again, think first local law, except it's possible that you may be having a look at federal law for whatever your issue is. But that's constitutions. So constitutions set up the structures of the governments. The second place law comes from, and we're going to talk later at great length about this, is from the courts. Courts, appellate courts particularly, write opinions. And those opinions, this is judge making a ruling on a case, writing an opinion saying this guy wins because of this and because of this principle and because of that. That's called precedent. Judge-made law is called precedent. And of course the legislatures hate the word judge-made law because they think judges shouldn't be making the law. But they are, and they are in fact interpreting the laws that are passed by legislators at all levels. God, if you ever looked at a new lengthy piece of legislation, you read it and you just go, what? How could intelligent people have done this? So it all ends up in the courts. And it's for the judge to decide what do they mean, what were they trying to do, what was the purpose. So a lot of what the judges are doing is interpreting legislation. The ruling in a case by an appellate court is called the holding. We hold the following. We, the judges, hold that this is the law that applies in this situation. As we said, and they may be reversing what the court did before, or they may be saying, yeah, you know, we're going to talk about appellate courts are reviewing what a lower court did. And they make a decision of was the court right or wrong, and then they have a holding, an explanation of the law as it applied to the facts in the case. All of those holdings together are called precedent, and precedent is prior judicial action on a certain subject. The importance of that is other courts have to follow it. And that's what creates certainty in law, to whatever extent certainty exists. You know that if this court has previously handled exactly this type of case, and this is the way they ruled, this is how they're going to rule again. And that tells you what to do. And that tells other courts what to do. And other courts are required to follow the appellate court of the court above them. And that's how they decide what to do as well. My boss, the appellate court above me, said in this case I got to do da-da-da-da-da. So you can predict that's what this trial court is going to do because that's what the appellate court in his district told him to do, and that's the precedent and that's the law in that area. But all of this stuff is out there everywhere, and every jurisdiction is different, and different courts follow different appellate courts, and that's kind of the law in that area. And when you get up the pyramid to the top, well, hopefully that applies to everybody. Yes, sir.
You mentioned that, you know, it's kind of like a requirement to follow precedent, so to
Yes.
speak. When does that change? Like, when
does
does a
it change?
precedent change?
When the appellate court changes it.
So it would have to, the court above would have to say, you know what, you guys made an error in your judgment. This needs to change now?
Sort of. Yes, you're exactly right. But that doesn't mean that a court can't change its mind.
Okay.
And they do. We, the Fifth Circuit Court of Appeals in federal in New Orleans, think we were wrong 20 years ago when we told you this is the way it ought to be.
Mm-hmm.
We now think this is the way it ought to be. And that, we're going to talk about this exact structure in a little while in great depth, but that ruling of the Fifth Circuit Court of Appeals, federal in New Orleans, will apply to 7 or 8 southern states that are in that circuit, and will apply to all of the federal district courts in all of those states. And all of a sudden, everybody goes, wow, they've totally flip-flopped on an issue, and now they say, go do this.
Mm-hmm.
And that's why staying current on what the law is important. What
Now,
the Supreme Court did 200 years ago may be important, unless they change their mind.
Now, as a judge on a local level, say the state of Florida, or even a municipality, I'll bring it even closer. If I feel as a judge that maybe their ruling was a little off, because even there's dissents, right? Sometimes the judge, they have dissents. It's not always unanimous. So as a municipality, if I feel like the Supreme Court kind of was off on that judgment, do I still have to follow their ruling if my case is similar to theirs? Yeah.
Does a lower judge have to follow that ruling?
Yeah.
No.
Okay.
He's supposed to, but he can say, I disagree,
Mm-hmm.
and this is what I think.
So if they
He's
have
a
a
very-
similar case.
Identical case, he can say, I disagree.
Okay.
You would predict that he would not,
I got you.
and the reason you would predict that he would not, and we're trying to have predictability here and precedent and have some idea before you go to court what the judge is going to do.
Mm-hmm.
Because here's what happens if he differs. The next appellate court says, you're wrong, you're reversed, send it back down, have a trial and do it our way, and we're going to tell you how to do
I
it.
got you.
Now, if that happens often enough, people start thinking you're an idiot, and you come up for a reelection, and your opponent says, this guy was reversed 70% of the time. You know, so they don't want that to happen. It's embarrassing among their colleagues, it's embarrassing among the lawyers, but they may take a chance. Give you an example. We have, as I know you all know, court opinions in Key West for Monroe County, Dade County, Broward County on the gay marriage issue. Circuit court judges, trial court judges are deciding not to follow the Florida Constitution. You know, we have that constitutional amendment that says it will only recognize marriage or as a man and woman or something. I forget what it says, but the point is, even the Constitution, and of course the Supreme Court, and Florida Supreme Court, and the appellate courts have all said, no, we gotta, these are the rules. These judges, these 3 judges in these counties have had the courage to say, well, we think it's wrong.
Yeah.
Those cases are going up on appeal. Yeah. As I'm sure you've seen, Pam Bondi, the Attorney General, the next day has said, I'm appealing, I'm taking it up, and that's the way it's supposed to be done. But yeah, judge is required to follow precedent unless for some reason he wants to stick his neck out and try to change the law. And he's got a very good chance of being shot down for it. But if they didn't do that, it would never change. Yes, sir.
So, since judges are elected,
I'm sorry?
judges are elected,
Uh-huh.
how are they supposed to know on every case? Is it the lawyer's job to tell them, look at this case? Or do they go back and have a
Are
team
you
of
asking me,
people?
do they do their own research to
Well,
see
like,
what
how are they
precedent
supposed
is?
to know? I mean, they can't know everything about
Yeah.
every single case.
I think I understand
Is
your
it the lawyer's responsibility?
Absolutely, 100%.
That
At the lowest level, it's the lawyers. It's the lawyers all the way up, but here's the difference. As you work your way up the food chain in courts of appeal, they have more and more staff. They have law clerks. Every U.S. Supreme Court justice has 4 law clerks. That's the most prestigious job you can get coming out of law school, be a U.S. Supreme Court clerk. Those guys do a lot of the research. This is all they do. Help their judges write opinions and research. However, at every level, lawyers are telling the judges what they think the law is. These guys say, I think this is the law and this applies to the facts. And this guy over here saying, no, he's wrong, don't follow that. This is the law. And the judges are reading both sides. And both sides are citing cases and are citing statutes that they think supports their position. And it's amazing how on one little issue, you can find all these lawyers on this side citing 7 or 8 cases that we think mean this. And the lawyers on the other side are citing a dozen cases that we think say the opposite. Or in fact, are citing the same cases, but we don't think that's what they say. We think it means no. Urging the judge to rule in their favor. And of course, then when the judges write the opinions, the cases that they're citing, as they go through the opinion, you saw the opinions in the book. Those gray case things in your book, those are court opinions. That's actual reported court opinion on a case. But the law that they cite in there, the cases in the book are pretty poor. And I'm going to point out the ones particularly that please don't read if you haven't. But largely what the judges are going to do is say, we think the law of such and such a case applies from 1912, and here's the citation of the case, here's how you find it, and here are the facts there, and we think they apply here. Well, that's not because the judges know every case that's ever been out there. It's because one of the lawyers wrote a brief or argued and said, Your Honor, we think this is the case that's the best. And, you know, a lot of people talk about the last thing a judge hears is what your ruling is going to be. Somebody gets to go last. You know, you go back and forth maybe and argue and ask, but the guy who goes last is the one the judge remembers when he leaves the room to go think about how's he going to rule. But fortunately, they're written briefs and this is all on paper, and then hopefully they read both sides and make a decision. and their clerks help. And as more clerks they have, the more help they get. But that's where the law is coming from in terms of to the judge. Certainly the judge may know all about it, may know the issue, but you're right, of course, they don't know every issue and every type of thing. And every set of facts is unique. Yes, ma'am?
When a precedent is overturned or reversed, do prior court cases have the opportunity to come back and be retried based on the reversal?
Maybe. It may be that an appellate court will say, trial court, you applied the law incorrectly. Retry the case. But not always. They may make a decision that actually becomes a final ruling, even if it's to the contrary. They may, I can't think of a good example right now, but it may require a retrial, but not necessarily. And of course, if it's further up the line, the court may just be saying that the intermediate court, you said it wrong. But that doesn't require another trial. But it's getting ahead of me just a bit because we're going to go there at length in a minute and talk about the different functions of the different courts at each level. And as you'll see, each appellate court is telling the courts underneath them what to do, and they're telling the courts underneath them down to do. And when you get down to the bottom of the trial court, they may be telling the trial court to do something different, or they may not. And of course, the situation we're all most familiar with is in a criminal case where they come back and say, all right, have another trial. But in civil cases, it's not necessarily going to require another trial. It may just be, nah, change the ruling. Yes, sir.
Just to piggyback off of what her question was, all right, if I had a case that was ruled in one way, and then a new case came, it got appealed, and the higher court made them change the ruling, but my case was ruled similar to that one, can I get my case retrialed as well, since the Supreme Court said that case was done wrong?
Maybe, maybe not.
Okay.
There's a principle in the law, and I'm fishing for the word, where you've already had your day in court and you're done. That's the reason it's not double jeopardy like it is in criminal stuff where we can't try it twice for the same crime. But what we're saying is your case has already been decided and it's over and you're done. If 15 years later the judge has changed their opinion, that doesn't mean that you can go back and sue the guy that you sued 15 years ago and say, hey, I wish like hell I'd sued you today. It's not likely.
Can it be reopened?
Maybe.
Okay.
Maybe. A lot of that, let me say to you candidly, I'm not a trial lawyer. I don't do this kind of stuff. And have never wanted to and wouldn't be caught in the courthouse dead, except that I get summoned for jury duty every now and then. That's it. I don't like litigation. I, of course, get exposed to it and get dragged into it sometimes and have clients involved in it and assist them in the substantive ends of it, but not the mechanical rules of the rules of procedure and the pleadings. And there is a word for what you're talking about. I'm sorry?
I'm sorry.
No,
I
please
just
do.
spoke openly. In most of the cases it's called res adjudicata, which means that it's done, the decision is final. To bring it back to trial 15 years later, it's very, very difficult, like the professor had just said. They're not gonna go back to all the cases that has been already decided and open them. That's one of the differences between common law, English law, and Roman law. We can go back to the statutes. Here, it's very difficult.
Thank you. You're right. It would create a nightmare. I mean, as you can imagine, if we could, let's go try the stuff from the 1800s because, you know. But it tells you, it tells you how to change what you're doing in the future and that you might get a better result. But it's not likely that you're going to have the ability to, let's just start over again. Okay, we're going to talk a lot more about this stuff. This was the intro to judge-made law, and we're going to get into that in a half hour or so at great length. That was the second place that law comes from. It came from constitutions, came from judges, precedent. The third thing is statutes. These are your legislative bodies producing law, legislation. United States Congress, Florida Legislature, County Commission, City Commission, County Commission, City Commissions pass ordinances. Ordinances are what they call, the same as what we call statutes. They're the law for and they apply to the area involved. County ordinances only apply to Broward County. Fort Lauderdale city ordinances only apply within the city limits of Fort Lauderdale. So there is a legislative body cranking out legislation at all 4 of these levels. And that's the third area where we get law. And there's a little relationship between that second and third area. We touched on this before, a lot of the legislation doesn't make sense or is subject to differing interpretations. So the courts are interpreting statutes and are writing opinions saying, we think this is what the legislature meant, and therefore this is how we think this law should be applied to the facts in your case. So that's an interaction between the courts and the legislature. Oh, and the legislators hate it. What do you mean? That's not what we meant. So they come back next year and they change the statute to be what they thought they meant. But then the courts probably have to tell them what we think they meant this time. And there's that kind of interplay and button heads, but it helps the public because it helps us figure out what do the laws mean, how do they apply. Without that, you can just pick a statute and I worked for a committee in the legislature. We wrote statutes, and by God, when you're writing it and you're focused on this is what this is what the law means, you think it's just as clear, crystal. And lawyers get a hold of that, and one guy says it means this, another guy says it means that, third guy says it means that, because that's how they want it to read, and that's how they want it to apply to the facts in their case. And that's how they're going to go to court and say, Your Honor, this is what they meant. And the judge is going to decide. And then it's going to go up to an appellate court. Because almost always, these are big issues. What did the legislature mean? It'll go to an appellate court, and it may even go on to the Supreme Court. Try to figure out what are they saying, what are they doing? Is it or isn't it constitutional? Does it violate the Constitution? So there's kind of an interplay of that third thing we talked about, the constitutional law. Okay, there is a fourth area where law comes from, and this is huge. Getting huger by the moment. Administrative law. These are rules and regulations of administrative bodies, departments, divisions, cabinet officers, as you know, or there's the Minister of Commerce, for lack of a better term. Might have all these departments under him, might have all these divisions. All of these departments and divisions are given the authority by the legislation that creates them to adopt rules and regulations. Oh, and they do. And boy, they just crank them out right and left. I'm going to give you an example of one of these. And you're not responsible for the specifics of what I'm telling you, but I just want you to see the scope and breadth. But first, let me say an example is at the Florida level. I mean, at the federal level. Federal level, you got Congress, and you got Congress cranking out legislation, creating departments, like creating the Environmental Protection Agency. Let's have one. Let's staff it. And let's let it pass all its own rules and regulations to tell everybody what to do. Now, Congress will pass CERCLA and RCRA and all of these acronyms for these Environmental Protection Acts. You're going to find most of these things end in A because it's an act. The Resource Recovery Act, the Comprehensive Environmental Act. And in each of them, they'll say, here's what we think the law is, and here's who you have to deal with, what department, and that department gets to pass its own rules and regulations to tell you what to do. And those rules and regulations, administrative rules and regulations, those are the fourth area law we're talking about. I want to give you a more specific example in Florida. Some of you may have been exposed to this. Anybody do any work in your development life with condominiums? You're obviously been exposed to Chapter 718 of the Florida statutes, I assume. Great. And tell me your name, sir.
Tyler?
I'm sorry?
Tyler?
Thank you, Tyler. In the 70s, we didn't have any law in Florida on condominiums. We had condominiums going up. People building apartment buildings and lawyers figuring out ways to sell units and let you own a unit. And the legislature decided, let's have a condominium act. And they created a whopper. It's named the Florida Condominium Act. And it's Chapter 718 of the Florida statutes. You don't need to know that. We're going to talk next week, the next course, 2 weeks out, about condominiums at length. But I just want to give you an example of the scope and breadth of this kind of stuff. So the legislature in the 70s says, let's have a condominium act. And it's got 7 parts now. And I mean, a part is like, it's not just like a chapter in a book. A part is like another whole book. With dozens or maybe even hundreds of chapters of statutes in each part. But they start this thing out with, the first section is, here's 30 new definitions for you. Words you may or may not have heard of before, but these are the definitions. Number 17 is, innocently, the division. Division means the division of, here's what they say. The division means the Florida Division of Condominiums, and of the Department of Business Regulation, and with just that stroke of the pen, they create buildings and offices and jobs and staff and structure. And they're going to go on to say throughout the statute, you're going to deal with the division on these issues relating to condominiums, and the division is entitled or instructed is the right word, to pass rules and regulations to implement this legislation. To how to regulate people, what to do, what to file, when to appear before us, what to get approved, and crank out all your own regulations. And so we've got the legislature no longer creating law. We've got each of these divisions. And this is one of a zillion divisions. But they go on in the Condo Act and they say, now here's part 2, and we're going to regulate developers. We're going to regulate what we want in their sales contracts. And we're going to regulate that deposits have to be held in escrow, because we, the legislature, think that people are coming down here and signing contracts. And this is what's happening. People are signing contracts to buy condominiums before they're built. Pre-sales, out of a trailer. And they give the developer 50 grand. And he'd sign up a bunch of those, and then things weren't looking good, so he takes everybody's deposit and he goes south, and they never build a building. So the legislature says, let's escrow all those deposits. Immediately those deposits have to go into an escrow account. Now this is, we're going to protect everybody. And then they say, of course, condominiums are going to have associations. Every condominium has an association, must have an association. This is, if anybody who doesn't know anything about condos, this is an owners group. This is all the owners belong to the association, and associations have boards and officers and rules and regulations, etc. That's a whole other little world of stuff we're not going to talk about. But the legislature said those those associations are going to have to register with the division. And the division is going to tell them how to operate. And the division is going to get to pass more rules and regulations to regulate the associations, not just the developers, but now we're going to regulate all the associations. When they have annual meetings and books and records and rules and okay. They have a part 4 on different types of condominiums, leaseholds, conversions, stuff like that. Then they get into a huge, bigger section on part 5 on regulating the sale of condos, whether before or after construction, and all of the disclosures that we, the legislature, think everybody should know before they buy a condominium. And this is what creates that nightmare of a thing called a prospectus. And if you go look at or sign a contract to buy a condominium, a new one, and in some cases an older one, you get what's called a prospectus. And that's a book full of stuff that you never wanted to know, but the legislature says you have to have it. And it's copies of the declaration that creates the condominium, and articles and bylaws of the association, and budgets and stuff. And before any developer can sell a condominium in Florida, his lawyer's got to prepare one of those things. It's got to be filed with the division, and the division has to approve it. And every purchaser has to get one. And until the purchaser has received one, the purchaser has a right to cancel his sales contract. A year later, you didn't give me a prospectus, I cancel, never mind. Values are going down, not looking good, you didn't give me a prospectus, deal off. Legislature created all that, and this division reviews all those things and makes sure that they're adequate before you can sell. They have another Part 6, interestingly, on how you convert apartment buildings into condominiums. Condos are not all brand new buildings. Condos are sometimes old apartment buildings, and somebody decided, let's sell the units. So legislature says, let's give all kinds of rights to the tenants who are in there. You can't just kick these tenants out. So they have all their own rights, and they get to bitch to the division and appeal and have hearings and et cetera. And this stuff is not static. Every year, the biggest political football is how are we going to amend the Condominium Act this year? Legislators go up there and all their little condo commando committees come to them and say, maybe I think you should do this, you know, and these guys have a lot of votes and they have a lot of clout. So the legislature says, yeah, great idea, and introduces a bill, and the bill says, let's change the Condominium Act as follows, and then they pass this new legislation and they change it. So every year this thing is growing. And every year it may be, the legislature may be instructing the division to do more stuff and regulate more people and pass more new regulations to carry out what we just decided to do. In 2010, the legislature decided there were a lot of distressed condominiums in Florida. Not decided, there were. They acknowledged that there were. This was, you know, after the 2007 recession. If you're not familiar with condominiums, condominium associations got hurt real bad. People quit paying their assessments. Condo associations ran out of money. How are we going to pay the utility bill and the water bill and the lawn man? Because nobody's paying their assessments. They're not paying their lender either. Units are empty. Lenders are taking them back. Condominiums are going to hell. The legislature wanted to encourage people to come in and buy up a bunch of condominium units, but not become a developer, and not have to file all this crud, because they wouldn't do it. People wouldn't buy them and start over as a new developer, having to give warranties on these old units that have been occupied by who knows who. So they created the Distressed Condominium Relief Act, section Part 7 of the Big Condo Act, to try to help ways for developers to sell units. My point is, it changes. It changes on subjects you thought you already knew were settled, and then they dream up all new stuff too. This is one chapter of the Florida statutes. There are over 1,000 chapters of the Florida statutes. This is one department or division, and who knows how many hundreds there are in Tallahassee, regulating all kinds of stuff, and this is one that regulates real estate, but there are others. You know, we used to have statute books, so you could see how many pages these things were. But you don't see that anymore. All this stuff you see on a computer screen now. So nobody knows how many pages there are, but the Condominium Act, when it was last published in book, was over 100 pages. And they've messed with it since, and of course, then they're telling the division to pass rules and regulations that are more and more pages. This is all law that could affect what you're doing. And that's it. These are the four areas. The four areas were Constitution, courts, legislative bodies enacting statutes, and administrative rules and regulations passed by administrative agencies. This stuff, and let me add one more comment. Remember, this is happening at the local level too. This is the county saying, let's have a building department. And let it pass its own rules. And let's have an environmental department with its own rules. So it's not just state agencies, it's not just federal agencies, it can be county agencies, city agencies. And they have rule-making authority. And this is more volumes of crud that you need to know that can affect you and what you're doing. This stuff all ties together. A little bit like we talked about before about the courts interpreting the statutes. But I want to give you how I see it as the big picture, and this is just my take on it, and how this plays into the three branches of government, and we all learned the three branches of government and civics and whatever. We've got the legislature enacting all of these laws, including under their umbrage the administrative rules and regulations. We've got the executive branch. It's the president, the governor, the mayor if you got one, whoever your executive is. They enforce all this stuff. And they have cabinets and they have departments and they run all these agencies that administer all these rules, and that's the executive branch. And then we've got the judicial branch of the government. And the judicial branch of the government is to translate what all these guys are doing, or at least decide, here's what we think they meant, to tell you what it's about so that you can hopefully act accordingly and follow what the courts say the law really is or means, and also to rule things as unconstitutional if a court determines that one of these legislative bodies has done something that violates the Constitution, violates the federal Constitution, violates the state Constitution, violates the county charter. So, we've got the areas of law, we've got who enforces them, and now we're going to get heavily into the courts. And we're not going to get heavily into the other branches of government. We're going to talk about the courts because that's what affects more directly what we're doing. There are two kinds of courts. There are trial courts and there are appellate courts. Now we're going to discuss three levels in a minute, but for now there are two kinds of courts. There's a trial court. The trial court's job is to decide what are the facts here, who's telling the truth, what really happened, and then to apply the relevant law to those facts. In order to determine what the facts are, and maybe have a jury. There are only juries in trial courts. There are no juries in appellate courts. You don't have a box of 12 people sitting over there telling the Supreme Court what to do. Juries are there to help decide what are the facts. Who are we going to believe here? Which witnesses are credible? But you don't always have a jury trial. Very often, more often, you'll have a trial before just a judge. But that's the trial court. You can listen to the testimony of the witnesses. This is the only place you have witnesses, is a trial court. And maybe have a jury, maybe not. And then that judge is going to decide what is the relevant law that applies to what he has decided the fact, he or she has decided the facts are. And is going to make a decision. That's your trial court. Then we have appellate courts. we're going to talk in a minute about two types of appellate courts. But appellate courts are courts where the decision of a trial court is appealed. That's why they're appellate courts. They handle appeals. Their job is simply, sounds simple, to decide whether or not the trial court correctly applied the law. That's it. No juries, no witnesses, no testimony. Just lawyers arguing what happened in the court below to the judges and telling them why they think the judge was wrong or why they think the judge was right as to the law. They don't get to complain about the judge believed so-and-so and I think she was lying. And they get to complain about whether the judge allowed so-and-so to testify because that might be a matter of law. But they do not upset the factual determinations made by the trial court. Their job is simply to decide, was the law correctly applied by the trial court? That's it. And make a ruling, make a decision, make a holding that we talked about earlier. Their decision of the appellate court is called a holding. And it's going to be published. And that's where you're going to get access to judge-made law. The holdings of these appellate courts, with some limited exceptions that we'll talk about. You're not going to see anywhere the rulings of the trial courts. They're just not published. Okay, they're in the newspaper sometimes, but they're not published in a legal journal such that they are precedent. And secondly, remember what we talked about, the purpose of precedent in these holdings is for the lower court to follow? Yeah. Well, there is no lower court than the trial court. And the trial court doesn't have to do what the guy in the next office did, so there's really no purpose in publishing their decisions. Okay. We've got, yes sir?
Is there any statistics on when you take something to the appellate court, like what your odds are that you're going to get it overturned? I mean, is it very limited?
You hear those things quoted all the time. I wouldn't want to tell you anything. Some people say 95%, some people say 70%. Hopefully it's more than 50% that is going to be consistent with what the court did before. And hopefully it's not going to be wrong 50% of the time. But trial lawyers throw that around. And they also, this is like the notches in their gun. I got a 95% success rate,
yeah.
You know.
They only take the good ones.
Good for you. You know, maybe only take the easy cases.
Yeah.
I couldn't give you anything that I think is reliable. Okay. Because I've teed it up, and we're going to talk about this some more in a minute, there are two levels of those appellate courts. That's why I said earlier there are three levels of courts. There's trial courts, and then there are two levels of appellate courts. There's the intermediate appellate court. That's the first step up the ladder. And then, of course, as you would guess, there's the Supreme Court. Not always named the Supreme Court, but in things that relate to us it is. But in other states it's called the Court of Appeals. And, different names in different states, but there is always a highest court in every state, whatever its name is. And of course there's a highest court in the federal system, and we all know what that is. Now, what cases take place in what courts? At the first juncture, you got to decide federal courts or state courts. Federal court's jurisdiction is extremely limited. Very rare you're going to be in federal court. Now, of course, I told you earlier, if you file bankruptcy, you're gonna be in federal court, yeah. But overall, you're not going to federal court very often. Congress has decided, and the Constitution has decided, what types of cases are gonna be heard by the federal courts. And it's very limited. There are matters that arise under federal law, under the Constitution. But basically, the US Constitution said that we want the states to handle everything else. So the jurisdiction, this is called jurisdiction. What is the jurisdiction of the court? The jurisdiction of the state courts is everything that isn't in federal courts. Everything else. And it's very limited what's in federal courts. Now, the few questions where the federal courts are going to be there, we said are federal questions. Federal statutes, treaties, federal constitution, and one other big exception. Federal matters, and one more thing. This is called diversity jurisdiction. And diversity jurisdiction is what puts all kinds of other matters, without regard to subject matter, in federal courts. Diversity jurisdiction is simple. In a very simple example, litigation between people in two different states over anything, over a state matter. State law may apply. A guy in Alabama sues a guy in Florida. Well, he sure doesn't want it heard in Florida by a Florida court. He's going to get hometown. He thinks the Florida courts are going to favor the Florida guy, so he wants it held in Alabama. The Florida guy said, nah, I don't want to go there, and I don't want Alabama courts. They're going to favor you. They're going to hometown you. So the federal courts are there to handle litigation between corporations or persons from different states. The amount in controversy has to exceed $75,000. But you know, most lawsuits do. But this is still pretty rare. You know, your auto accident cases, your rarely criminal cases are going to be in federal court. Criminal court in federal cases is if you violated a federal criminal statute. Like we talked about, federal statute. That's why you have some crimes in federal courts. That's why you have a U.S. attorney. But the federal courts are rare. You're rarely going to be exposed to federal courts. Diversity jurisdiction is the area where federal courts might be interpreting state law and might be ruling on what we would otherwise think are state matters, and might be ruling on real estate matters. Could be. Could be these guys in these two states are suing each other over who's got the right to take water out of the Apalachicola River that flows through Alabama and Florida. Maybe. In any event, there's one other area. This is not an area, but it's a doctrine that affects a lot of what goes on in federal court. And we touched on this earlier, and that's called the federal preemption doctrine. And this is something built into federal law. I think it originates in the U.S. Constitution. Yeah, it does. It comes from the Constitution. And it says simply, we talked earlier about that we, the feds, are going to leave to the states most everything except the limited things that we say the federal courts are going to handle. But the federal preemption doctrine says that states may not regulate any matter that we, the federal government, say that we're going to regulate. Federal preemption. We, the federal government, preempt what you're doing in the states. Now, doesn't mean you can't have some legislation too in an area, but you can't do it contrary to federal law. Immigration is a biggie and a hot button issue that we could talk about for hours. But federal government says we're controlling immigration. We got the border control, we got Homeland Security, and they say that they heavily regulate immigration. Well, that's pretty debatable whether they are or they aren't doing their job there. But theoretically, that's a federal area only. When the states try to get involved in immigration, they get sat on pretty hard. Arizona tried to pass that law that says we can stop and frisk everybody who looks Hispanic just to see if you violated a federal law. Quickly, the administration came down all over them, and I think it went through the courts. The point is you can't. You cannot, in a state or a county or a city, legislate and take action in an area where the federal government has preempted your right to do so. And the reason that's important is because that ends up in federal court a lot. It's not a court, it's not a jurisdiction, it just creates lots of federal matters that will be held in federal court. Okay. Yes, sir.
Before you,
How does that, so how does Colorado and Washington get away with legalizing marijuana when it's not legal federally? For recreational use, say.
Good question.
And why haven't they stopped it? Or is that in the courts now, or?
It's certainly going to be.
And I can see it for medical reasons, but
Oh,
not,
well, yeah,
but not for
medical
recreational.
maybe, but Colorado, no. Colorado's just have at it.
Yeah.
Even for medical use, though, the federal government still comes in and can raid any, whatever you want to call it, place that they're keeping medical marijuana at, but what gives the state the right to allow that in the first place?
You bring up a very good point, and candidly, I hadn't thought of that as it relates to federal preemption. There is no question that it still violates federal law. And the federal DEA has a right to come in and bust a guy for having a joint in Colorado if they want to. They're not. It doesn't mean it doesn't violate federal law, it just means they're not enforcing it there. That's a very good question. What's been done, though, interestingly, in all these states, thinking it through, it's been done by constitutional referendum. The people in that state have said, this is what it's going to be. It hasn't been the Colorado legislature saying,
Right.
hey, let's pass a law that's contrary to federal law. Maybe that's the difference. I'm just making that up, I don't know. I don't know that anybody's ever tested these laws to see if they really do violate the federal law. And I'm not sure candidly whether the medical use of marijuana violates federal law. But the wide open, go ahead and sell it, traffic in it, certainly does. I don't know. Good question, good point, good question.
kind of piggybacking off of the concept there, if aren't states given the right to enforce get stricter with the rules, the federal laws?
You may. There's no question that the states are allowed to legislate in the same area as long as it's not contrary to federal law or inconsistent with federal law, but they may be stricter.
So going back to the immigration thing, if federal law doesn't allow certain immigration tactics, if as a state I decide, all right, we want to frisk, I don't want to use the Hispanics, but whoever, let's do Jamaicans. If we want to, if we want to frisk.
You want to frisk a Jamaican?
If we want to do that, what stops them from doing that? Because they can just go off the fact that, you know what, this is just us being more stricter trying to enforce immigration rules.
I think it's gonna be a tough row to hoe to not do something that violates Border Patrol rules, immigration, federal, there's no question that there's a federal immigration service, and you ain't gonna create a whole Florida immigration service. People are still coming into the United States.
Yeah.
And the United States government has said, we're gonna regulate that.
Yeah.
So I think frankly, immediately, it would be held, I don't, if the Florida legislature started trying to do that, they'd have everybody screaming at them, hey, you just can't do that.
Is that almost
Ipso facto violates federal law, period. Don't do it. Don't waste your breath, don't waste your effort, don't waste our time.
And if all the Jamaicans leave, Florida will disappear. Just so you know.
One day you may be right.
That was loosely just used as an example, okay? Very loosely.
I'm
Please
sure
don't
you remember
take-
that.
This is interesting stuff, and this is what creates a lot of litigation in federal courts, and why they get a lot of publicity. Yeah.
I just want to answer, because I have the answer for the marijuana.
I'm sorry.
For the
That you do?
marijuana federal law. In 2013, the U.S. Conference of Mayors adopted a resolution arguing that the state's localities should be able to set whatever marijuana policies work best to improve the public safety and health of their communities. So there was an amendment of federal law to explicitly allow states to craft their own marijuana policy.
Good job.
So it wasn't a federal level?
The thing is on our ballot, is that what you're saying that's coming up on our
Yes.
ballot, our amendment two?
Yeah.
Interesting.
The thing is, in Colorado, it's legal, but the feds and the FBI, they control the facilities. So everything inside of the facility is monitored by the FBI. Even the tickets, every plant, everything is controlled by the DEA and the FBI. The collection of the money comes in special bags and takes it to, their problem is the banks, because they still consider money laundering from illegal drugs.
It's an oil and cash business.
So only local community banks are allowed to receive that money in special bags that are pre-approved and precinct
Drug money.
by the FBI.
Nice.
So they look at it
No idea.
as
cool.
like liquor and stuff. They
Yeah, so maybe you're complying with federal law. I had no idea that the federal government was ever being that cooperative. That the FBI would, I frankly didn't know the FBI had much to do with drugs. I always thought it was the DEA. but-
FBI, DEA, and they all monitor, and I was in one facility once and I saw it, so,
Did you bring back anything?
no.
Just curious.
Okay, that's a great subject, and it really does tee up a good issue, and I don't have the answer for that.
I think it's legal in Jamaica too, though.
It's not legal in Jamaica.
I bet it is.
Contrary to popular belief,
The
it's
term
not
you-
legal.
Yeah.
So the term used when federal law stomps on state law is federal preemption, correct?
See,
The term you use when federal law stomps on the state law, when that happens, that type of case happens, it's called federal preemption, correct? That's
federal preemption is states don't adopt any legislation inconsistent with what we're doing.
okay.
Inconsistent, that's all it says. It doesn't mean you may not legislate in this area at all, but you may not legislate inconsistently with what we're doing. But you can be more restrictive. Gun control. Second Amendment, right to bear arms. Theoretically, that could mean that only the federal government could regulate guns. That's not the case at all. States obviously do. Cities and counties do. Chicago. And that gets often tested as violating the federal preemption doctrine. And I think it's a good example. At every level, you have gun control, legislation, and enforcement, and departments, and often when the NRA thinks that a local government has done something that is an area that it believes there's federal preemption or that the Constitution preempts the right, then they come in with their Second Amendment story. So it's, I think that's a real good test. I wish I knew more about the marijuana test. The immigration, I think, is likewise one that we're going to see more and more and more. but I don't think it's ever gonna open the floodgates for the states get to decide what to do. And that would pretty well be a nightmare too. Whichever state has the most lenient law is gonna get overrun, you know? Okay, now, so we talked about jurisdiction. That was jurisdiction. What types of cases are handled in the state courts or in the federal courts? Now we're going to talk about the setup of the courts in both of those systems. We're going to start with state courts, and I'm going to pass out something to you in a minute, but I want to just make a couple preliminary comments before you start looking at what I hand you. As you know already, there are 3 levels of courts in Florida. Trial courts, intermediate appellate courts, Supreme Court. In Florida, our judges are elected. They're elected for 6-year terms. Nonpartisan elections, you're not supposed to say whether you're Democrat or Republican, but everybody knows. And, but you don't, the parties, you're not running on the Democratic ticket. Nonpartisan elections for 6 years to become a judge in Florida. Your election, where you run against somebody else, is at the trial court level. And that's where you get elected to the bench. Once you're on an appellate court, intermediate appellate court, or Supreme Court, you still have to run for re-election every 6 years. But here's what re-election means. It's not somebody running against you. On the ballot, you'll see a question that says, should Steve Ginestra be retained as a member of the Supreme Court? Yes or no? That's it. That's what you get to vote on. There's no other candidate out there. Nobody running against you. It's either are you in or are you kicked out? Yes, sir.
What if you get kicked out?
I'm sorry?
What if you get kicked out? What if they say
Then
no?
what?
Then they have to do another.
Then the governor appoints somebody. At each of these, the governor appoints a new judge. And frankly, getting a little bit ahead of ourselves, but that's how you move up from the trial court, where you got elected. That's how you move up to these appellate courts, is you get appointed by the governor. And then, once you've been appointed by the governor, every 6 years you stand for re-election, which means there's a word for that, it's called merit retention. Does this judge merit being retained in office, yes or no? And they don't vote anybody out. However, recently, pro-life people, in not liking some opinions of Florida Supreme Court judges on pro-choice, pro-life decisions, have decided to run campaigns to remove judges from office.